Thank you for joining us today for a half-hour webinar on duty of care. I would like to start by acknowledging the Wurundjeri Woiwurrung people of the Kulin Nation, traditional custodians of the land on which I am presenting today, and pay my respects to their elders past and present. Our webinar today will be focused on duty of care in relation to children and young people. However, much of what we speak about today is directly applicable to organisations working with vulnerable people in the disability and aged care sectors. But please note that other obligations may also exist in these sectors, which we will not cover today. Some of the content I will be discussing today can be confronting and distressing, as I'll be talking about child abuse and harm to children and young people, including physical, verbal, psychological, and sexual abuse. Should you at any time feel that the content is overwhelming or distressing, please feel free to step out of the session. Support services are also listed on the screen if you feel you need the support following the session. My name is Patrice Fitzgerald, and I am the Principal Lawyer and Director at Safe Space Legal. I have practiced as a lawyer for nearly 20 years in child protection, institutional abuse, and child safety for over a decade now. At Safe Space Legal, we are the first law firm in Australia to practice exclusively in child safety and safeguarding, and we assist organisations to ensure that they comply with their legal and moral obligations in relation to keeping children and vulnerable people safe from harm. I'm also joined by Brett Hogan, who is a Senior Associate at Safe Space Legal. Brett has more than 35 years' experience working with children and young people and people with disabilities, and in addition to his legal qualification, holds a Bachelor of Social Welfare and qualifications in disability. If you work with children and vulnerable people, I have no doubt that in your positions you are well aware of the legal concept of duty of care, and you have participated in child safety training where duty of care has been discussed on many occasions. Yet, despite all the child safety obligations that exist across Australia and all the safeguarding training that takes place, we continue to see organisations breaching their duty of care to children and vulnerable people. On the screen are just some of the recent media articles where organisations and individuals have failed in their duty of care, and there have been horrific outcomes. Child safety is everyone's responsibility, and every person has a role to play to ensure that children and young people are protected from maltreatment and abuse. It is important that everyone working with children and young people take proactive and preventative steps to promote the safety and well-being of children and young people and protect them from exposure to harm, trauma, and abuse. At Safe Space Legal, our motto is prevent, comply, respond, which are the three elements of safeguarding which create and promote the safety and well-being of children and vulnerable people within organisations. It is a continuum and a constantly evolving process. We are focusing on duty of care today, and when we look at the concept of duty of care, you will see that it fits all three elements of the safeguarding cycle up on the screen. Organisations and individuals within the organisation have obligations to prevent children and young people from being harmed, which we'll talk about today. Prevention includes identifying risks and taking steps to mitigate those risks, as obviously this is the basis of duty of care. Organisations and individuals within the organisation are required to comply with their legal obligations to ensure that safety of children and young people they are working with. We will talk about some of your obligations to comply with legislation today, which is also an essential element of risk mitigation. Organisations and individuals within the organisation have legal and moral obligations to respond to allegations of abuse in a child or person-focused manner, utilising processes which are consistent, transparent and timely, and ensuring investigations are trauma-informed and thorough. By responding properly to a risk, concern or allegation, you are likely to reduce further risk of harm to the child and other people working within the organisation. After an individual or organisation responds to a concern, it then takes us back to prevent again, as you'll identify further risks and concerns which could be mitigated. Safeguarding is a cycle and it's a constantly evolving process. So as we go through the webinar today, have a think about where each of your actions fit into the safeguarding cycle. And if part of the cycle is missing, then think about how it can be addressed. On the 15th of December 2017, the Royal Commission into Institutional Responses to Child Sexual Abuse issued their final report. Two of the major recommendations coming out of the Royal Commission were the introduction of the 10 child safe standards and the implementation of a reportable conduct scheme. The child safe standards recommended by the Royal Commission became the national principles for child safe organisations, and across Australia, some states have enacted legislation to implement the 10 child safe standards into law. In Victoria, New South Wales, Tasmania, and from 2025 Queensland, the child safe standards have been enacted. However, regardless of whether the child safe standards have been implemented in the state you work, your organisation should be guided by the national principles. National Principle 8, which is Child Safe Standard 8 in some states, and in Victoria it's Child Safe Standard 9, states that physical and online environments promote the safety and well-being of children and young people, while minimising the opportunity for children and young people to be harmed. When we talk about duty of care today, know that the national principles also reiterate the common law principle of duty of care. So what does duty of care actually mean? I'm going to pass over to my colleague, Brett Hogan, to talk about that.
Thanks, Patrice. Today we're here to talk about duty of care, and I'm sure everyone viewing the webinar today has heard the term duty of care and knows that they hold a duty of care to children and young people within the organisation where they are working. But what does it actually mean? And what does it mean in practice? Today we're going to go through the elements of what the term duty of care means, and especially in relation to day-to-day operations. Organisation staff and volunteers have a legal duty to protect the children and vulnerable people they have care, supervision and authority of from being exposed to reasonably foreseeable risks of harm. Duty of care is non-delegable, which means that any person who has a legal duty of care is not able to delegate or shift that responsibility onto another person. Every person working with children and vulnerable people owes a duty of care with respect to those children and vulnerable people, and are required to take all reasonable measures to protect the child or vulnerable person from reasonably foreseeable risks, where a reasonable person with the same level of skills and responsibility would have foreseen the risk was likely to occur. Your obligations in relation to your duty of care may differ according to your role and the situation or incident. However, case law has shown us that people who work with children and vulnerable people are held to a particularly high standard of care. Duty of care also extends to minimising risks posed by any individual associated with an organisation, including third parties, and can extend to outside of operating hours and outside of an organisation's property, such as on excursions, camps, and online. Individuals with duty of care obligations must always consider what precautions are reasonably expected to prevent a child or young person from being exposed to harm. When making this assessment, you must consider the probability of harm occurring if no action is taken, the likely seriousness of the harm, the burden involved from precautions being taken to avoid risk, and the social utility of any activity proceeding when it also has the capacity to expose a child to risk. A staff member will be held personally liable for breaching their duty if a child or young person has experienced harm, the harm was reasonably foreseeable, whether a reasonable person in the same circumstances as the staff member would have been able to predict that the child or young person would be exposed to harm if the risk was not mitigated, and the staff member failed to recognise the level of risk and establish a reasonable standard of care, therefore making the staff member responsible for the harm caused. So we've gone through the legal definition of duty of care, but the most important thing I want you to walk away with today is understanding what it means in practice. In order to comply with your duty of care, it all comes down to two things: identifying risks that exist and taking steps to mitigate those risks. So when you think about duty of care, I want you to start considering it from the perspective of risk. Say to yourself, I owe a duty to the children and vulnerable people I work with to take steps to mitigate risk to them. For organisations that work with children and young people, risk comes in all shapes and sizes. As Patrice said before, duty of care also ties in with some other really important child safety obligations, including the Child Safe Standards. We spoke before about the Child Safe Standards being a recommendation that came out of the Royal Commission. Compliance with the standards are an essential element of ensuring that an organisation and an individual is taking reasonable steps to mitigate risks of harm. National Principle 8 for Child Safe Organisations, which in Victoria is Child Safe Standard 9, requires that organisations maintain physical and online environments which promote the safety and well-being of children, while minimising opportunities for harm. In Victoria, the Commission for Children and Young People has provided guidance around this standard, including that employees and volunteers can identify and mitigate online and physical safety risks. Online environments are used in accordance with an organisation's code of conduct and child safety and wellbeing policies and procedures. Risk assessments and management plans are established for foreseeable risks. Procurement procedures and policies are in place where organisations contract services from third parties. Preventative measures are in place to prevent foreseeable risk, and identified risk is responded to in a timely manner. Employees, volunteers, children and caregivers are provided with information about online safety risks. Complaints mechanisms are in place to appropriately respond to allegations of maltreatment or abuse in physical and online environments. National Principle 8 is really an emphasis on promoting the safety and well-being of children, whilst the organisation and its staff comply with their duty of care. While it is not an exhaustive list, some common risks in physical environments can include lack of appropriate supervision, which could lead to a child being exposed to accidental or intentional harm, slips, trips and falling hazards, not securely putting away hazardous materials, exposure to extreme temperatures, not securely putting away or supervising a child using objects which could cause harm, lack of care in managing a child's sensory needs, lack of care in managing a child's allergy or dietary needs, and staff and volunteers who are not suitable or pose a risk to children of child abuse. And some of the most common risks in online environments include exposure to online content which can be inappropriate, illegal, explicit, violent, graphic, racist, or extremist, exposure to pornography or sexualized content, bullying, harassment, stalking, manipulation, and other cyberbullying conduct, grooming conduct, including engaging with children online, either on social media or through private messaging, sharing of child sexual exploitation material, sexual harassment, non-consensual messaging, and pressure to engage in sexualized discussions with peers, adults, or strangers, sharing personal details about family, friends, school, or their whereabouts, which impacts a child or young person's safety and security. So once we've identified what risks exist, steps to mitigate risk have to be put in place. The organisation is responsible for much of this risk mitigation, and often leadership will have already taken steps to mitigate risks that have been identified. Organisations should have policies and procedures in place which are compliant with their legal obligations and meet the Child Safe Standard requirements. You must ensure you read, understand and comply with these policies to ensure you are taking steps to mitigate risk. Organisations should provide you with child safety training and support you to understand your obligations, including duty of care. You must ensure that you attend the training, participate and understand the training. If you don't, you need to ask questions and report back. Ignorance is no excuse when it comes to the law. Staff must ensure that their conduct meets the obligations set out in any applicable child safety code of conduct and other relevant codes of conduct. Your organisation should have recruitment practices in place to ensure employees and volunteers working with children are suitable. Your organisation should conduct risk assessments and audits on a regular basis to ensure online and physical environments are safe for children and young people. They will then place responsibilities on staff to reduce those risks. Supervision rosters, excursion forms, policies around administration of medication. Staff must comply with these obligations and policies. Organisations should maintain a safe physical environment for children. If an individual notices that something is not safe in the physical environment, they must take steps to remove the risk. Staff should provide adequate supervision to prevent incidents from occurring. Children and vulnerable people and their caregivers should be able to easily access and understand complaints handling processes, and organisations should ensure risk is identified and responded to appropriately. Staff members must understand their role when it comes to responding to concerns, allegations, or risks. In addition to duty of care, a number of other legal obligations exist in relation to children and young people. We don't have time to go into detail about these today, but be aware that depending on the state in which your organisation conducts services, other obligations do exist, and in order to comply with your duty of care, you should be aware of and comply with these other legal obligations. I'm going to pass back to Patrice now to talk about some of the well-known and recent case law in relation to duty of care.
Thank you, Brett. So today we've spoken about the term duty of care and what it means in practice. Unfortunately, there is no shortage of case law across Australia where organisations and individuals have been found to have breached their duty of care, and the outcome for children, the staff involved and the organisation has been horrendous. I'm going to talk about some of those cases now. So there's a vast amount of case law, as I said, which is based on a lack of supervision and appropriate risk mitigation. And one of the recent cases I'm going to talk to you about today is a coronial inquest into the death of Christiane Adrian Root, where the outcome of a school breaking its duty of care to a student at the school resulted in the death of a student. On the 17th of March 2023, the Coroner's Court of the Australian Capital Territory handed down a decision into the death of Christiane Adrian Root, who is known as Adrian. The events which led to Adrian's death, following a horrific accident during a school PE activity on the 18th of October 2018, highlights the importance of organisations, in this case a school, having appropriate policies and procedures in place to safeguard and protect children from reasonably foreseeable risks of harm. By way of background, Adrian was a student in Year 10 at Campbell High School in the ACT. On the 18th of October 2018, at 10 a.m, he attended the school gymnasium for a PE session. 112 Year 9 and 10 students, including Adrian, and 5 teachers left the school grounds and went to the base of Mount Ainslie to play a game called Capture the Flag. Teachers conducted a risk assessment at the area prior to the game being played to assess if the area was safe. In addition to the risk analysis of the area, teachers possessed a first aid kit and mobile phones and completed a verbal safety briefing with students to explain the rules of the game, safety rules, and that any silly behaviour would be reported to teachers. There were several observation points for teachers to supervise the game, and teachers walked around the game field to monitor the game. Due to the incline and dense bushland of the game field, the jail area where the accident occurred was not in the line of sight of supervising teachers. At 10:45 a.m, Adrian and some other students were in the jail area. The students in the jail area noticed a large log, which was approximately 6.03 metres long and 188 kilos in weight, and attempted to pick up the log. It is reported by the students that the log was pushed greater than 45 degrees, and then it began to slip. All the students jumped out of the way except for Adrian. The log fell and struck Adrian on the head. Adrian was reported to have been knocked unconscious. Adrian was pronounced dead at 2:56 p.m. and his cause of death was assessed to be as a result of circulatory failure, secondary to traumatic brain injury, consistent with blunt force trauma to the head. During the inquest, following review of the policies and guidelines in place for PE, Coroner Stewart found that capture the flag was not an approved activity and therefore required a risk assessment, management plan, and approval from the principal. Due to the game being played outside of school grounds, it was considered an excursion, which required parental permission outside of the enduring permission, which was obtained when a student started at Campbell High School. The policies and procedures in place were not complied with, and during interviews with staff, it was clear that most staff were not aware of how to correctly categorise capture the flag. Coroner Stewart found that this led to an obvious inadequacy because staff were not able to define what requirements were to be followed, and training was not provided to them on how to locate and implement guidance to safeguard against incidents of harm. Coroner Stewart found the complacency and long-term delivery of capture the flag without serious incident or injury made it very unlikely that the incident was foreseeable by the staff. However, the incident leading to Adrian's death should have been reasonably foreseeable. For when young people are placed in jail for an extended period of time without adult supervision, as it can be predicted that they would be bored and engaged in mischief and misbehaviour. Coroner Stewart found that the amount of supervision provided was considered inadequate, and increased supervision ratios could have avoided the incident occurring, as it would have led to swift action to disrupt the student's behaviour. In this case, Coroner Stewart found that the death of Adrian was a direct result of the high school and the directorate not having clear guidance from existing policies and procedures, which led to inadequate supervision and poor risk management. Coroner Stewart found that if appropriate policies, procedures, and guidance had been in place, the risk which led to Adrian's death would have been reasonably foreseeable and therefore avoidable. The next case I'm going to discuss is a well-known High Court case from 1982, which is once again about a school's failure to supervise, which resulted in breaching its duty of care. This is also the case that establishes that duty of care is non-delegable. So in the case of Commonwealth and Intervene, several minutes before the formal commencement of school, a 15-year-old student jumped off some steps near a flagpole and swung on the halyard attached to the flagpole. At the time this was occurring, the truck at the top of the flagpole fell and hit the student in the head. There was no formal supervision in the yard at the time the incident occurred, and the students had sustained significant head injuries. The court found that the school failed to provide adequate supervision at the time of the incident and did not provide a safe premises for the students, being well aware that children engage in risk-taking behaviour when they are left unsupervised. The court found that the school was negligent in its duty of care to prevent foreseeable risk, being aware that students would swing on a flagpole and not padlocking the halyard to the flagpole. In addition to supervision, there is well-established case law regarding organisations' obligations to protect children and young people from harm from other children and young people. This case is a 2013 case, which was in the New South Wales Court of Appeal, and is in relation to a failure by a school to protect a student from bullying. So in the case of Oyston and St Patrick's College, Jasmine Oyston had been attending St Patrick's College from 2002 to 2005 and raised concerns that she was bullied by the popular girls at school, which involved verbal and physical abuse at school and in the community. Jasmine made a complaint to her English teacher in year 7 or 8, however, no action was taken. At the end of 2002, Jasmine made a further complaint. However, no incident report was completed and no action was taken again. In 2003, Jasmine commenced seeing the school counsellor and reported the bullying to 4 different teachers. However, no action was taken. Jasmine stated that she stopped making reports as it became apparent to her that any such reports were not assisting her. Jasmine subsequently developed an eating disorder and experienced suicidal ideation. On the 24th of September 2003, whilst in detention, Jasmine was completing a behavioural form where she wrote that she wanted to kill herself. The school did not respond to her cry for help and did not notify her parents, refer her to counselling, or investigate the matter. In 2004, Jasmine developed depression and had regular panic attacks. engaged in self-harming behaviour and stopped attending school regularly. Following an incident where Jasmine was physically assaulted and a complaint was made, the court found that the school did not follow up the incident, there was no investigation, and the student was not suspended as per the school's policy. The court found that Jasmine was regularly, if not relentlessly, bullied, and that the school was aware of the bullying and had a duty of care to take reasonable steps to ensure that Jasmine was protected from bullying, including taking reasonable steps to ascertain the identity of the perpetrators and to take such action as was reasonable to prevent repetition by those persons of such conduct. The court found that the school breached its duty of care by failing to devise, implement, and maintain an adequate anti-bullying program. Failure to act upon Jasmine's complaints of bullying and failure to adequately investigate and prevent the bullying of which Jasmine complained by supervising, disciplining, and counselling the perpetrators. The next case which I will discuss, you may be aware of the essence of the case as it was well publicised case which attained media attention due to Ms. Leifer being extradited back to Australia in relation to criminal proceedings. The case of Ehrlich and Leifer emphasises the importance of organisations having good governance and ensuring that children and young people are protected from harm by the people who are unsuitable and pose a risk of abuse to children and young people. In this case, Hadassah attended school between 2003 and 2006, where Ms. Leifer was the headmistress. While she was a student at the school and after she had finished school, Hadassah was repeatedly sexually abused by Ms. Leifer. Hadassah's sister was also sexually abused by Ms. Leifer, and prior to the sexual abuse occurring, Ms. Leifer was found to have engaged in grooming, building Hadassah's trust, using information from her sister about her family life, finding ways to spend time alone with her by removing her from class, providing her with one-to-one tutoring, and driving her to and from school. The court found that Ms. Leifer's conduct should be attributed to the school as they had a responsibility to deter the tortious conduct of their employees. And given Ms. Leifer was acting in the course of her employment when the conduct occurred, the court found that Ms. Leifer's conduct was also the misconduct of the school. Evidence was given that Ms. Leifer had significant power and authority and was involved in all aspects of the school, with her level of authority described as unrestrained and unrestricted. All complaints were required to go through Ms. Leifer, and staff and students raised concerns that they could not make a complaint due to being scared of Ms. Leifer and having no other avenue where they could raise concerns. The court also found that the school breached its duty of care to students by not providing appropriate oversight and governance and not providing a complaints mechanism process for staff and students. At Safe Space Legal, we offer a full range of safeguarding services to support organisations across Australia to be best practice leaders in child safety. Our services encompass all three elements of the safeguarding cycle, and we work closely with organisations to tailor our services, including child safety investigations, child safety training, audits and gap analyses, child safety legal advice, drafting policies, procedures and templates, conducting root causes analysis and making recommendations following critical incidents, and representing organisations in enforcement action. And we now operate a new service called the Safe Space Support Line, which provides on-call, high-level advice in relation to safeguarding and managing critical incidents. Thank you for attending the webinar today, and we look forward to hosting another webinar in approximately 2 months, where we'll be talking more in depth about risk mitigation and the process of risk management. If anyone has any questions they wish to ask following the webinar today, please write your question in the chat or send us an email and we'll get back to you as soon as possible. We also offer a half-hour complimentary MS Teams meeting to discuss your organisation's safeguarding needs and how we may be able to assist. Once again, thank you for joining us today.